Hello and welcome to the Vercammen Law Office Legal Podcast. This edition, we're looking at a unreported appellate division case where the appellate court found there was no reasonable suspicion to support an investigative detention by the police. This is State versus Peralta. So the defendant here appealed the denial of his suppression motion. Defendant was charged with possession of cocaine with intent to distribute. His charges followed a multi-state drug investigation that led police to learn that a New Brunswick address and white SUV were connected to the investigation. DEA agents here observed the SUV leave the New Brunswick address and requested assistance from the county task force detectives in continuing surveillance. The detectives located the SUV and watched it for about an hour before walking up to find a male sleeping inside. Eventually, detectives saw two men exit a residence and approach that SUV holding a bag. Although the detectives did not see any suspicious activity, when one of the men entered the vehicle, the detectives executed a takedown and restrained the three men, including the defendant. At the suppression hearing, the detectives testified they did not know the names of the suspects before approaching the SUV. The detective who approached defendant, who was standing near the rear of the vehicle, testified he ordered defendant to take his hands out of his pockets. Defendant admitted that "I got something on me," and pulled out a clear bag with white powdered substance. On appeal, the defendant argued that the trial court erred in denying his suppression motion where police lacked reasonable suspicion to initiate an investigative detention, and the detective's testimony demonstrated the defendant was effectively arrested prior to the seizure of evidence without probable cause. The appeal court here vacated the defendant's conviction and remanded for further proceedings. The appeal court noted that the arresting officers testified that they did not know the identity of the persons they were looking for and did not observe any suspicious activity before detaining defendant. Thus, the court held the officers lacked any reasonable suspicion to support a detention, tainting defendant's subsequent voluntary surrender of the contraband. And the citation, and this is the name of the case, that is State versus Peralta. For more information on any kind of drug and suppression case, visit website njlaws.com, and for representation, contact Ken Vercammen's office in Edison at 732-572-0500. Thank you. Have a great day.